Welcome to those of you that have joined. We've just opened the live link, so we're just going to wait for a few minutes to allow everybody to join before we start. Welcome to those of you that have joined. We've just opened the live links. We're just waiting for a few minutes to allow everybody to join before we start. Welcome to the Five Stone Buildings webinar program. We have just opened the live link, so we're just waiting for a few minutes to allow everybody to join before we start. Whilst we are waiting for everybody, I will just remind you of the house rules. So just to remind you that this webinar is being recorded. If you have any questions throughout this webinar, please put your questions into the Q&A box at the bottom, and our speaker will try to come to the questions at the end if we have time. If you do not wish to be identified when asking your question, then please tick the anonymous box so that our speaker will not identify you in their response. And I'd just like to remind you that the Five Stone Buildings website now has a separate section for webinars where you'll be able to find the recording of this webinar and any slides used during the presentation and any previous webinars that we have held. I will now hand over to Penelope.
Well, hello everybody, and welcome to what I'm hoping might be up for an award as one of the most esoteric of our Chambers webinars. I suspect there are many of you in the audience who have been kept awake at night worrying about whether you can exercise a power of advancement in relation to your Hancock and Watson trusts. But can I say the excitement from my perspective in being instructed in this case is that it was one of those points of trust law where there was no authority. So it had to be argued from first principles using such cases as had been decided. So Joe, next slide, please. So this was a matter that came on before Master Clerk for decision in January of this year. And judgment was delivered about 6 weeks ago. And it concerned the exercise of the power of advancement and the way in which that might tie in with Hancock and Watson trusts. Joe, next slide, please. And just to deal with what those Hancock and Watson trusts were, what they are, and what we were dealing with here. The trusts we were dealing with involved 13 sub-trusts for grandchildren of the original set law. And those trusts were as I've set out on the slide. And forgive me for going through them in a bit of detail, but actually it's going to help with the understanding of the decision that was finally made. So the trustees were to hold the remaining fund and the income on trust for all or any one or more of the beneficiaries who attain the age of 25 or shall be living under that age at the end of the trust period, in such shares as the trustees shall at any time or times during the trust period by any deed or deeds revocable or irrevocable appoint. So what it looks like one has here is an absolute gift to those beneficiaries who attain the age of 25 years, and it is only the only power that the trustees have is to decide the shares in which they should hold their entitlement on their attaining their 25th birthday. Joe, next slide, please. But then those trusts were followed by a proviso, and that was a proviso that is going to be very familiar to many, if not all of you in the audience. And it's a proviso that says the allotted share taken by the beneficiaries, in this clause referred to individually as the beneficiary under the trusts declared by clause 9, shall not vest in him or her absolutely, but shall be retained by the trustees and held on the following trusts. So in other words, you have what looks like an absolute gift on the previous slide, followed by a proviso that in fact the beneficiaries do not get the share at 25, it's retained by the trustees. And the trusts were, first of all, that the trustees would hold that share and the income on trust for the beneficiary during his or her life. Joe, can we have the next slide, please? And then there were some pretty exciting trusts, and I mean use the term exciting in a chancery sense, following that the trustees would hold the allotted share and the income after the death of the beneficiary, first of all for the first and other sons of the beneficiary, successively according to seniority in tail male with remainder. So in other words, an entail that one finds very rarely nowadays, but it would be for the eldest son to take first, and then his sons. If the eldest son was not alive, then it would be the younger son, and so on. And then it would be for the first another sons of the beneficiary in tail with remainder. And the difference between A and B, of course, would be that the trusts in B would include daughters if the male line ran out. But you still had to have a son for those trusts to work effectively. And then finally, and this is important for the decision, the trusts went to that beneficiary absolutely. So if all of this failed, then the beneficiary would actually take an absolute interest. If we could have the next slide, please, Joe. So the question that the trustees were pondering was, could they advance the shares of each of the beneficiaries to them? These were trusts that were substantial if you looked at them overall, somewhere in the region of 12 to 13 million. But if you looked at each of the 13 sub-funds, they contained a really quite modest amount of money, just under £1 million. And these were beneficiaries who were young adults and wanted to purchase properties. And it made sense to advance the funds to them rather than keeping them in the trusts, which was going to result in administrative charges, but also the 10-yearly inheritance tax charges. And so the trustees thought about their power to advance, and the trusts contained the Section 32 power, but it extended, as is commonly the case, to the whole of the fund rather than just a 1/2 of the beneficiary's presumptive share. So I suspect that all of you could recite Section 32 of the Trustee Act with your eyes closed, but I do want to go back and have a look at it in the same way that when I was presented with these papers, I went back and had a look to see precisely what the terminology said. So the trustees may at any time or times pay or apply any capital money subject to a trust for the advancement or benefit in such manner as they may in their absolute discretion think fit, of any person entitled to the capital of the trust property or any share thereof, whether absolutely or contingently on his attaining any specified age or on the occurrence of any other event, or subject to a gift over on his death under any specified event, or on the occurrence of any other event, and whether in possession or in remainder or reversion. That's the first part of Section 32. And all I want to point out at this point is that a beneficiary who has to be entitled to the capital of the trust property, but that can be absolutely or contingently on attaining any specified age. Jo, can we have the next slide, please? And then we get to Section 32, the proviso. And I should say that this is Section 32 as it applied to trusts prior to the amendments that were made in 2014. And the proviso that's relevant for these purposes is C, that no payment or application shall be made so as to prejudice any person entitled to any prior life or other interest, whether vested or contingent, in the money paid or applied, unless such person is in existence and of full age and consents in writing to such payment or application. Now, in most cases where one is concerned about this, it's very straightforward. Where you have trusts to A for life, remainder to B, then unless the consent of A has been dispensed with in the trust deed, which it often is, then A has to consent before there can be an advancement in favour of B. And there are obvious reasons why that's the case. A will be entitled to the income of the share and quite rightly may feel that B shouldn't make off with the capital without being consulted. So that's the straightforward situation. It's also notable, and I've put this in bold on the slide, that the consent has to be from such person in existence and of full age. And I'll come on to the important part that particular part of the proviso played as far as this case was concerned. Jo, can we have the next slide, please? So, what were the problems for the trustees in this case? Well, the problems were this. First of all, if they were left with the situation of saying that the beneficiary took as the ultimate capital beneficiary of the share, they had the problem of getting the consent of all those who went before. So they couldn't simply advance to the beneficiary on the basis that they were the ultimate default beneficiary if all the other trusts failed. And the difficulty that presented itself was that the application was being made in favour of beneficiaries who had not yet had children. So there were a whole host of unborns who were not in a position to consent. And the question was, and I'll come on to this, the court didn't ultimately have to decide it, as to whether in fact you need the consent of those unborns, which obviously you can't get. And secondly, if you did, whether the court could actually override the necessity for those consents. And so what was thought about is whether or not you could say the beneficiary had an absolute interest in capital under the first part of the gift. And if you remember, what I started with was the first part of the trusts, which actually gave the beneficiaries an absolute interest aged 25. And then that was then cut down by the proviso. And that is where the rule in Hancock and Watson comes in. So what are Hancock and Watson trusts? Well, the rule as set out in that case was that where there is an absolute gift to a legatee in the first instance, and trusts are engrafted or imposed on that interest which fail, either from lapse or invalidity or any other reason, then the absolute gift takes effect so far as the trusts have failed, to the exclusion of the residuary legatee or next of kin, as the case may be. Now, a lot of the decision in Womble Bond Dickinson concerned the nature of Hancock and Watson trusts. And if you simply look at the rule set out there, it looks as if it only takes effect when there is the failure of trusts. And what does it really mean? Well, what the court was really saying in Hancock and Watson was that if somebody has, either in their will or in a trust, set out that they want to benefit somebody absolutely, then in those circumstances, the court should give effect to that. And if the subsequent trusts fail, well, it doesn't matter, because you have that absolute gift that has been provided either by the testator or the settlor. Joe, next slide, please. And the rule has been applied far more widely than perhaps that last slide might have suggested. So it's not just been applied where there has been a failure of the following trusts. So, for example, in the Attorney General and Lloyd's Bank, it was used to determine what sort of interest certain children had under a trust for the purposes of estate duty. And it was held there that they had an absolute interest, which continued until they had some children, when that absolute interest was liable to be defeated because the subsequent trusts came into play. Interestingly, the rule has been considered in Hong Kong rather more recently perhaps than it has been considered in England and Wales, by no less than Lord Walker, Robert Walker, and he said it's a rule of construction that actually you apply it where you have a situation where there is an absolute gift followed by trusts that are engrafted on it. And there's also a very helpful decision of Mr. Justice Peter Gibson, as he was at that point, in a case called Watson and Holland, setting out how you identify Hancock and Watson trusts, and pointing out that in most cases you have, as you did have in this case, an absolute gift followed by something like a proviso, provided that the beneficiary doesn't get the absolute share, but that there are trusts that will come into play. And finally, the case of Fife and Irwin also makes it reasonably clear that the rule will apply even in circumstances where there isn't a failure of the subsequent trusts. And if one thinks about it and stands back for a moment, that rather makes sense, because, of course, if you are going to characterise that initial gift as an absolute gift, it doesn't make sense to only have it as an absolute gift in circumstances where you've got a subsequent failure of trusts. Jo, could we have the next slide, please? So the first question that the court had to determine in the Womble Bond Dickinson case was whether or not the trusts that I've shown you right at the very start did constitute Hancock and Watson trusts. I was somewhat surprised, I think it's probably fair to say, that that was being argued at all. I have to say I'd looked at these trusts and immediately thought, absolute gift, followed by engrafted trusts. But there was really a rather clever argument put forward as to why they were not Hancock and Watson trusts. And that was on the basis that you didn't need them to be, because the reason why the courts had characterised trusts that are set up like this as Hancock and Watson trusts is in order to look at what the intention of either the testator or the settlor was in respect of that initial gift, which, so that when the subsequent trusts failed, it would be possible to see what was intended. What was argued here was that the fact that the beneficiary was also the ultimate beneficiary, and it was spelt out in the trusts, meant that you didn't have to look at Hancock and Watson. Your answer was there. If the trusts fail, then it goes to the beneficiary. My argument in the case was that, in fact, all the Draughtsman was doing was spelling out what he knew would be the effect of the trusts. So in other words, what was intended here was if there was a failure of the trusts, then the initial beneficiary would take. And that argument did ultimately prevail. But there was a very clear exposition in the judgment of all the cases that related to Hancock and Watson, and the cases that, and what the cases meant, what principle that you could draw out of the cases. And so from that point of view, the case did have a look at the whole principle underlying engrafted trusts. And ultimately, the court found that the effect of the trusts was that each beneficiary had an absolute interest in capital, which would be liable to be defeated on the birth of a son. And of course, as you'll recall, going back to the entails, you needed a son to kick off the subsequent trusts. So until that event occurred, it was clear that the beneficiary had an absolute interest in capital, but that interest was a defeasible one. Can we have the next slide, please, Jo? So the next problem that I mentioned earlier was there was no doubt in this case that the beneficiaries had an interest in capital, but the question was the prior consent of the unborn beneficiaries required. Now, it's an odd concept, isn't it? The idea of somebody who's not yet being born being required to consent. And there's a very helpful decision, re Beckett's settlement, where the judge thought that the whole idea was a nonsense. The idea that you could require the consent of somebody who was not yet in existence. But that rather goes against the grain of some other cases, and in particular, a case called IRC and Bernstein that was grappling with the question of whether you needed the consent of unborn beneficiaries in the context of accumulating income. And it's a frustrating case because the Court of Appeal doesn't actually come to any particular conclusion on the subject, apart from saying that it's all very difficult and that probably you do need the consent of unborns. So this was why it was so important to establish that the beneficiaries had an absolute interest in capital liable to defeasance in relation to that initial gift, because it made it easier to argue that in fact there were no prior life or other interests. Jo, can we have the next slide, please? And as is often the way with difficult trusts issues, the question always, in my mind, is what do the editors of Lewin say in relation to this? And in this case, I was pleased to see that I had a Lewin lifeline, as I called it. And I have to say that there have been many cases where a Lewin lifeline has come to my rescue. And the authors of Lewin had actually given some thought as to whether or not Section 32 was applicable to Hancock and Watson trusts. And they had said, we consider that it's applicable since the beneficiary takes a vested interest in capital subject to satisfying any relevant contingency. That, of course, was attaining the age of 25 in this case. And that interest being defeasible in the event of others taking capital under engrafted trusts. And so what the authors concluded was until that interest in capital has been defeated, the beneficiary retains an interest in capital and the statutory power is available, although the interests of the other capital beneficiaries, at least if in existence, will perhaps amount to prior interests requiring their consent. So this proved rather tantalising in the sense of looking at the textbook and thinking, well, the authors actually think that Section 32 is applicable to trusts of this nature. What they don't have at the moment is the authority to back that up. and this is perhaps a nod to the authors of Lewin that it would be good if this case got a footnote in the next edition. So, Joe, next slide, please. The judge found, having looked very carefully at the authorities and having considered that passage in Lewin, that section 32, power of advancement, did apply where there were Hancock and Watson trusts, and it applied to that initial gift to the grandchildren. But it was then argued that in fact the unborns had a prior interest and their consent was required and it couldn't be obtained, and so that stymied any use of the section 32 power. And the master found this a difficult question to answer, and it rather depends on how one looks at section 32. It was the interest of the unborns prior to the interest of their parents. And I argued that in fact you had to look at this literally, that prior refers to the order in which the trust property is enjoyed, a life interest being enjoyed before the interest in remainder. It's always seemed to me that that's what section 32 is getting at, and I'm pleased to say that that is what the master found on that particular point. Joe, can we have the next slide, please? Now, the case also threw up some questions that remain unanswered, and to me these were extremely difficult questions, and I rather felt that if I hadn't got over the hurdle of establishing that section 32 was available, and if it was on the basis of the Hancock and Watson trusts, we didn't need the prior consent of any party, that we would be into really quite choppy waters. One of the questions we asked the court, if we got to the point of the court saying no, you can only use the section 32 power in relation to that beneficiary's ultimate interest in capital. And there are prior interests, and those are the prior interests of their unborn children under those entails. So, can the court dispense with the consent of those unborns? Well, again, somewhat tantalisingly, there was a case which looked as if it might help, called Re Forster. And Re Forster is a fascinating case. You'll notice the date of 1940, and it was heard during the Second World War. And an English woman who had entitlement under certain trusts had married an Austrian nobleman and therefore had become an enemy alien. And indeed, it had not proved possible in the conditions that then prevailed to contact her. And the trustees applied to the court as to whether they could distribute the fund and dispense with her consent to the exercise of the power of advancement. And the judge, and I think it's worth reading the judgment, it's very short and very tetchy. And the judge says, no, I can't dispense with consent. But then right at the very end, he said, but if there'd been an application under section 57 of the Trustee Act, I might have done it. Now, as you'll know, section 57 is a section of the Trustee Act that enables trustees to apply to extend the administrative powers that they have under the trust in order to do something which is in the interests of the trust, where the court considers it expedient to do so. I think that there were real difficulties utilising Section 57 in this case, not least that dispensing with the consent of beneficiaries looked to me as something that was rather more than an administrative power. And I think if the court had had to decide the point, we would have been in some difficulty. But it is interesting that the judge in Re Forster, who was a very experienced judge in terms of dealing with trusts, thought that might be the way out. The other route that I went down in terms of the court dispensing with consent was a case Re Beale settlement trusts. That concerned the old exercise of the power of sale under Section 30 of the Law of Property Act 1925, which I remember well, but I suspect there's quite a few in the audience for whom this will be legal history, where it was held in Re Beale that the court can dispense with the consent to the exercise of a power of sale. The difficulty with that, again, is that the power of sale it really is an administrative power, whereas the power to advance changes the beneficial interests under the trust. And then finally, as a matter of desperation, I turned to New Zealand and the case of Kane and Hutton, where the court in New Zealand had decided that the statutory power of advancement could be exercised and the consent of the relevant beneficiary dispensed with. The difficulty I had with that was not that the judges in New Zealand are extremely good equity lawyers and are generally to be relied upon. The difficulty was that the statutory power of advancement in New Zealand is rather different and actually does contemplate the possibility of the court dispensing with consent. As I said, the court didn't have to decide the question, and it did strike me that it would have been really quite an innovative solution if the court had decided that it could dispense with consent. Next slide, please, Jo. So we did manage to persuade the court that the power could be exercised, Section 32 power could be exercised, but we also then went on to ask the court to bless the exercise of that power, using the jurisdiction of the court in Public Trustee in Cooper, looking at whether or not it was a conclusion that the trustees might properly have reached. And so this was a rather different way of looking at matters. The trustees had determined that this was a sensible thing to do with these funds for the reasons I set out earlier, that these were young adults who would benefit from having the funds to purchase properties for themselves, and that this would give the beneficiaries a good start in life, whereas the funds were really not that substantial within the separate sub-funds, all of which were held on by different trustees to justify the administrative costs and to justify having to pay the 10-yearly charge. There were a couple of wrinkles in the application. One of the beneficiaries suffered from disability, and the trustees were not sure that they would want to advance the funds to him. And a couple of the beneficiaries were under 18 or so young, in such young adulthood that it didn't make sense to advance immediately. But the court found no difficulty in blessing the decisions that the trustees had made. And I think it's probably fair to say that by the time we got to that point, there wasn't really strong resistance on the part of the Council for the Unborn Beneficiaries. So we got our blessing. Can we go to the next slide, please, Jo? So what are the conclusions from this case? As I said right at the very outset, the subject matter of the decision was real esoteric trust issues, but it has really quite important everyday implications, because an awful lot of trusts are drafted in that way, with engrafted trusts. For those of us who who used to set up and see a lot of accumulation and maintenance trusts, which used to be tax efficient and not tax efficient now, they were frequently dealt with on that basis of having an interest in favour of a beneficiary at the age of 25, and then engrafting trusts onto that interest. So it made sure that the child or grandchild, as it often was, got that share, come what may, but if they had children, that the trusts continued into the future. Now, sometimes it's made clear in the engrafted trusts, which it wasn't in this case, that there is power on the part of the trustees to pay or apply capital to the particular beneficiaries who take life interests. But that's not always the case. So it's really worth looking in any particular trust to see whether or not there are life interest trusts, or whether they really are Hancock and Watson trusts with trusts engrafted onto them. And what this case establishes is, if you have beneficiaries who've not yet had children, where the beneficiaries under the engrafted trusts are not yet in existence, that Section 32 can be used. And I don't see why the reasoning in this case wouldn't also apply to an express power to advance contained in the settlement. But this case, it seems to me, can be looked at from the other end of the telescope as what it might inform Draughtsmen. And our lives would have been immeasurably easier, and a court application wouldn't have been needed in this case if there had been a method of dispensing with consent, or if consent had not been required at all. Although some thought needs to be given to that, of course, because the consent of the prior beneficiary might be a safeguard that the draftsman wants to build in to make sure, for example, that a widow has an interest in possession, or that children aren't disinherited in favour of their own offspring against their will. I've already mentioned it would be very useful if it was made clear that there was an express power to benefit the absolute beneficiaries, and it was the absence of that express power which caused the difficulties in this case. So it's an interesting decision. It's always a great privilege to be involved in a case which decides something for the first time. It certainly involved quite a lot of intellectual gymnastics. And can I say that when I started arguing the case in front of Master Clerk, her immediate reaction was, I don't see for one moment how the power of advancement can be exercised in favour of your clients who only have a life interest. And it was only after going through all the cases in relation to Hancock and Watson that we actually got to the conclusion that we did, that in fact you can exercise that power. So that's all I want to say, and I've clearly stunned everybody into silence because there don't appear to be any questions in the Q&A box. But if anything does occur to anyone, please don't hesitate to get in touch and ask me. And I hope that some case in the future may resolve the outstanding issues that Master Clerk at the end of the day didn't have to decide. Thank you all very much for listening so patiently.